The mahogany-paneled courtroom buzzed with the kind of tension that comes before a financial bloodbath. Evelyn Chen sat at the plaintiff's table, her shoulders slightly hunched as she smoothed her modest navy blazer for the 10th time that morning. Across the aisle, the Whitmore family had assembled like a pack of well-dressed wolves, their designer suits and confident whispers filling the space with an air of inevitable victory. Marcus Whitmore adjusted his platinum cufflinks and leaned back in his chair with the ease of a man who had never doubted his place in the world. At 42, he possessed the kind of inherited handsomeness that came with generations of good breeding and better nutrition. His salt and pepper hair was perfectly styled, and his custom-tailored charcoal suit probably cost more than most people made in 3 months. He glanced at Evelyn with barely concealed disgust, as if her very presence in his family's courtroom was an affront to the natural order. Before we dive deeper into this story of justice and hidden truths, I'm curious about something. Where are you watching this from today? Are you in a place where you've seen people underestimate others based on appearances? Drop a comment and let me know what state or country you're tuning in from, because this story about assumptions and reality might hit differently depending on where you are in the world. Beside Marcus sat his mother, Patricia Whitmore, a woman who had turned condescension into an art form. Her steel-gray hair was pulled back in a flawless chignon, and her cream-colored Chanel suit bore no wrinkles despite the early morning hour. She held her crocodile leather purse in her lap like a shield, occasionally glancing at Evelyn with the kind of disdain usually reserved for something unpleasant on the bottom of her shoe. The conversation between mother and son was barely above a whisper, but their body language spoke volumes. Patricia leaned close to Marcus, her diamond tennis bracelet catching the fluorescent lights as she gestured toward Evelyn's table. "She finally gets what's coming to her," Patricia murmured, her voice carrying just enough to reach the nearby court reporter. 23 years of this charade, and now we can finally be rid of her. Marcus nodded, his jaw set in the same stubborn line that had characterized the Whitmore men for generations. "The woman married me for money, Mother. She saw the family name, the estate, the business holdings, and she saw dollar signs. Nothing more." Behind them sat Marcus's siblings, a collection of entitled faces that seemed to have been carved from the same expensive marble. His older brother, Harrison, was a carbon copy of their father, all sharp angles and inherited arrogance. His wife, Celeste, kept checking her Cartier watch as if this entire proceeding was an inconvenience that was keeping her from more important matters like spa appointments and charity luncheons where she could be seen by the right people. The youngest Whitmore sibling, Vivian, was perhaps the cruelest of them all. At 38, she had never worked a day in her life, but considered herself an expert on everyone else's motivations. She whispered loud enough for half the courtroom to hear her commentary. "Look at her," Vivian said with a theatrical sigh. "Sitting there in that discount store blazer, trying to look pitiful. I told Marcus from day one she was after our money. Did anyone listen to me? Of course not." Celeste nodded in agreement, her surgically enhanced features arranged in an expression of practiced sympathy. "It's almost sad, really. She actually thought she could waltz in here and take half of everything the Whitmore family has built over 4 generations. The prenup will put an end to that fantasy quickly enough." At the defendant's table, Evelyn's attorney, Richard Holloway, was a nervous young man who looked like he had been assigned this case rather than chosen for it. His off-the-rack suit was wrinkled from stress sweat, and he kept shuffling through his papers with the desperate energy of someone who was in over his head. He was fresh out of law school, working for a firm that specialized in contested divorces, and this was clearly the biggest case he had ever handled. "Mrs. Chun," Holloway whispered urgently, leaning close to his client. "I need to be honest with you about our chances here. The Whitmores have one of the most ironclad prenuptial agreements I've ever seen. Their legal team is led by Stanford Morrison, who hasn't lost a case like this in 15 years. The family wealth, the business interests, the real estate holdings, they're all protected under the terms you signed before the marriage." Evelyn turned to look at her attorney, and for just a moment, something flickered in her dark eyes. It might have been amusement, or perhaps it was something else entirely. Something that suggested the nervous young lawyer didn't have all the facts about his client or her situation. "I understand the challenges we're facing, Mr. Holloway," Evelyn replied quietly. "But sometimes documents aren't quite what they appear to be on the surface. Sometimes the most important details are the ones that people don't bother to read carefully. Across the courtroom, Stanford Morrison was the picture of legal confidence. At 65, he was a legend in family law, particularly when it came to protecting old money from new threats. His silver hair was immaculately styled, his navy suit was custom-tailored to perfection, and his leather briefcase probably cost more than most people's cars. He had been the Whitmore family attorney for over 30 years, and he knew every detail of their financial empire. Morrison leaned over to Marcus with the satisfied expression of a man who was about to deliver a knockout blow in the first round. "This will be over before lunch," Morrison assured his client. "The prenup your family insisted on is bulletproof. She signed away any claim to marital assets, business interests, or inherited wealth. The most she can hope for is whatever personal items she brought into the marriage, and frankly, that wasn't much." Marcus smiled for the first time that morning, the expression transforming his face from merely arrogant to genuinely cruel. 23 years of pretending to love me, and she'll walk away with nothing but the clothes on her back. Justice, wouldn't you say? The bailiff called the courtroom to order, and Judge Helena Morrison, no relation to the attorney, entered with the kind of authority that comes from decades on the bench. She was known for her no-nonsense approach to complex financial cases and her particular distaste for gold diggers who tried to manipulate the legal system. As the proceedings began, Patricia Whitmore couldn't resist one final comment to her daughter-in-law. "Did you see the car she arrived in?" Patricia whispered to Vivian. "Some economy rental. Probably couldn't afford anything better once Marcus cut off her credit cards. It's almost pathetic how obvious her desperation has become." But Evelyn Chin sat quietly at her table, her hands folded calmly in her lap, her expression serene in a way that suggested she knew something the Whitmore family did not. Something important. Something that was about to change everything they thought they knew about money, power, and who really held the cards in this particular game. The irony was about to unfold in ways that would leave the entire Whitmore family questioning everything they had believed for over 2 decades. 23 years earlier, the same mahogany conference room had hosted a very different kind of meeting. A much younger Evelyn Chin sat across from Stanford Morrison, her hands trembling slightly as she stared at the thick stack of legal documents that would define the terms of her upcoming marriage to Marcus Whitmore. The prenuptial agreement was 47 pages of dense legal language, filled with clauses and subclauses that seemed designed to protect every penny the Whitmore family had ever earned. Morrison had been patient that day, almost grandfatherly in his explanations. "Now, Miss Chin," he had said, adjusting his reading glasses, "these provisions are quite standard for families of the Whitmore stature. You understand that substantial assets require substantial protection. The family has business interests spanning multiple states, real estate holdings that have been in the family for generations, and investment portfolios that require careful management." Young Evelyn had nodded, her dark eyes scanning the pages with an intensity that Morrison had mistaken for nervousness. She had asked careful questions about specific clauses, particularly those relating to asset protection and financial disclosure requirements. Her questions had been so detailed that Morrison had been impressed by her apparent desire to understand every aspect of the agreement. The most interesting thing about that long-ago meeting was what Morrison had failed to notice at the time. Evelyn had spent considerable time reviewing the sections about funding requirements for asset protection trusts and offshore holding companies. She had asked specific questions about liquidity requirements and capitalization standards that most people would have found mind-numbingly boring. Now, back in the present courtroom, Judge Morrison was reviewing the morning's preliminary arguments while the Whitmore family retreated to their favorite restaurant for what they clearly considered a victory lunch. The Whitmore patriarch, Harrison Sr., had passed away 5 years earlier, but he had instilled in his children a sense of financial superiority that bordered on religious conviction. At Chez Laurent, the city's most exclusive French restaurant, the family had commandeered their usual private dining room. The space was decorated in cream and gold, with crystal chandeliers that cast expensive shadows across imported marble floors. This was where the Whitmores celebrated their victories and plotted their next acquisitions, both business and personal. Marcus raised his glass of 1982 Bordeaux, a vintage that cost more per bottle than most people earned in a week. To the end of this charade, he announced with the kind of satisfaction that comes from crushing an opponent. 23 years of pretending that woman belonged in our family. And finally, we can close this unfortunate chapter. Patricia dabbed at her lips with her linen napkin, careful not to disturb her precisely applied lipstick. I still remember the day you brought her home, Marcus. Pretty enough, I suppose, but there was something about her that never sat right with me. Too quiet, too observant. Always watching and listening like she was calculating something. Harrison Jr. cut into his $40 steak with surgical precision. The prenup will handle everything, just as father planned. The family assets are protected, the business interests remain intact, and she gets exactly what she deserves for her years of deception. Which is nothing. Vivian smiled with the kind of cruelty that comes naturally to those who have never faced genuine consequences. I have to admit, I'm almost impressed by how long she managed to keep up the act, playing the devoted wife while obviously planning for this exact moment. But father saw right through her from the beginning. Celeste adjusted her diamond necklace, a piece that had cost more than most people's houses. The really pathetic part is how she actually seemed to think she fit in with us. Remember those early family dinners when she would try so hard to contribute to conversations about art and travel, as if someone from her background could possibly understand the finer things in life? The conversation continued in this vein for nearly 2 hours, with each family member contributing their own memories of Evelyn's perceived inadequacies and social climbing attempts. They discussed their plans for redistributing the assets once the divorce was finalized, their relief at no longer having to pretend she was welcome at family gatherings, and their satisfaction that the Whitmore name would finally be free from what they considered a shameful association. Meanwhile, back in the courthouse, Richard Holloway was having a very different conversation with his client. They sat in a small conference room that smelled of stale coffee and legal anxiety, surrounded by law books that looked like they had seen better decades. Mrs. Chun, Holloway said, shuffling through his papers with obvious frustration, I've been reviewing the financial disclosure statements from both sides, and I have to be honest with you. The disparity is even worse than I initially thought. The Whitmore family wealth is extensive, and the prenup seems to cover every possible asset category. Evelyn looked at her young attorney with an expression that might have been sympathy. Mr. Holloway, she said quietly, have you had a chance to review the funding documentation for the asset protection portions of the prenup itself? Holloway blinked in confusion. The funding documentation. I'm not sure I understand what you mean. The prenup outlines asset protection, but the funding mechanisms would be handled by the family's financial advisors and trust administrators. Evelyn nodded slowly, as if she had expected this response. Sometimes the most important information isn't in the primary document itself, but in the supporting financial structures that make the legal protections possible. You might want to subpoena those records as part of our discovery process. Something in her tone made Holloway look up from his papers. There was a certainty in her voice that hadn't been there during their previous meetings, a confidence that seemed oddly at variance with her apparent disadvantage in these proceedings. Mrs. Chun, he said carefully, is there something specific you think we should be looking for in those financial records? Evelyn smiled for the first time since the proceedings had begun. Let's just say that asset protection trusts require substantial capitalization to be legally valid, and the sources of that capitalization can be quite illuminating when properly documented. Back at Chez Laurent, Marcus was regaling his family with stories of his business successes, conveniently forgetting to mention the various financial challenges his companies had faced over the years. The Whitmore Group had weathered several economic storms that had destroyed lesser enterprises, though Marcus attributed this entirely to his own business acumen rather than to any external factors or assistance. The real estate development arm of our business is expanding into 3 new markets this quarter, Marcus announced, gesturing with his wine glass. The commercial properties alone will generate substantial revenue streams for generations to come. Father would be proud to see how we've grown the family legacy. Patricia beamed with maternal pride. You've always had such a brilliant mind for business, darling. Even as a child, you could see opportunities that others missed. It's no wonder you've been so successful in expanding what your father built. What none of them mentioned, because none of them had ever bothered to investigate, was the complex web of financial instruments that had made much of Marcus's success possible. The low-interest loans that had appeared at crucial moments, the investment partnerships that had provided capital during lean periods, and the financial guarantees that had allowed the Whitmore Group to take risks that would have destroyed other companies. Evelyn Shin sat in the courthouse conference room, watching her nervous young attorney struggle with documents he didn't quite understand, and she thought about all the things the Whitmore family had never bothered to learn about the quiet woman who had shared their name for over 2 decades. They had seen what they expected to see, and they had never looked deeper. That was about to change in ways that would redefine everything they thought they knew about power, money, and who really controlled the empire they considered their birthright. When court reconvened at 2 o'clock, something had changed in the atmosphere of the mahogany-paneled room. Richard Holloway entered with a completely different demeanor than he had displayed that morning. Gone was the nervous energy and scattered paper shuffling. Instead, he moved with the purposeful stride of a man who had discovered something significant during the lunch break. The Whitmore family filed back into their seats with the satisfied expressions of people who had spent the last 2 hours celebrating a victory they considered inevitable. Marcus adjusted his tie with casual confidence. Patricia smoothed her cream-colored skirt, and the siblings exchanged knowing glances that suggested they were already planning how to spend their afternoon once this legal formality was concluded. Stanford Morrison settled into his chair with the ease of a man who had dominated courtrooms for 3 decades. He opened his expensive leather briefcase and arranged his papers with a methodical precision that had made him legendary in family law circles. This case was supposed to be a simple matter of enforcing an ironclad prenuptial agreement, nothing more than a routine demolition of another gold digger's unrealistic expectations. Judge Helena Morrison called the court to order and looked expectantly at the plaintiff's table. "Mr. Holloway," she said, "I trust you used the lunch recess productively. Are you prepared to present your client's position regarding the marital assets in question?" Holloway stood, and when he spoke, his voice carried none of the uncertainty that had characterized his morning performance. "Your Honor, during the recess, my client provided me with additional documentation that I believe fundamentally changes our understanding of this case. Specifically, we have obtained the complete financial records related to the funding and establishment of the prenuptial agreement itself." Morrison's eyebrows rose slightly. "The funding of the prenup was handled through standard trust mechanisms established by my client's family financial advisors. I failed to see how funding documentation could be relevant to the enforcement of a validly executed agreement." Holloway smiled with newfound confidence. "That's precisely what makes this documentation so interesting, Your Honor. With the court's permission, I would like to present evidence regarding the specific sources of capitalization for the asset protection trusts that form the foundation of the defendant's claimed prenuptial protections." The Whitmore family exchanged confused glances. Marcus leaned forward to whisper urgently to Morrison, "What is he talking about? The prenup protects our assets, period. What does it matter how the trust accounts were funded?" Morrison raised his hand to silence his client, but his expression had shifted from casual confidence to careful attention. "Your Honor, I must object to this line of inquiry. The internal financial arrangements of my client's family trusts are not relevant to the enforcement of a prenuptial agreement. This appears to be nothing more than a fishing expedition designed to delay the inevitable." Judge Morrison considered both attorneys carefully before responding. "Mr. Holloway, I'll allow you to present your evidence, but it had better be directly relevant to the asset division questions before this court. I won't tolerate attempts to muddy the waters with irrelevant financial complexity." "Thank you, Your Honor." Holloway turned to address the courtroom, and his transformation was complete. The nervous young lawyer had been replaced by someone who clearly understood exactly what he was about to reveal. "Ladies and gentlemen, the prenuptial agreement signed by my client 23 years ago contains extensive provisions for asset protection through offshore trusts, domestic holding companies, and various other financial instruments. These mechanisms are designed to shield marital assets from division in the event of divorce." Patricia Whitmore shifted uncomfortably in her seat. Where was this going? The prenup was supposed to be straightforward, a simple matter of protecting family wealth from an obvious gold digger. Why was this young attorney talking about funding mechanisms and capitalization requirements? Holloway continued his presentation with methodical precision. "However, Your Honor, these asset protection mechanisms require substantial financial backing to be legally valid. The trusts must be properly capitalized, the holding companies must maintain adequate reserves, and the offshore accounts must meet international banking standards for legitimacy. Vivian whispered to her brother Harrison, "I don't understand what any of this means. Father's lawyers handled all the trust arrangements. Surely they knew what they were doing." The attorney opened a thick folder and withdrew a stack of financial documents. "Your Honor, I would like to present for the court's consideration the complete banking records, wire transfer documentation, and trust capitalization statements for all financial instruments referenced in the prenuptial agreement. These records span the period from 6 months before the marriage to the present day." Morrison stood abruptly. "Objection, Your Honor. These documents were not disclosed during discovery, and my clients have had no opportunity to review their contents or verify their authenticity." Holloway's response was smooth and prepared. "Your Honor, these documents were obtained through proper subpoena procedures during the lunch recess. My client has provided sworn affidavits regarding their authenticity, and the banking institutions involved have confirmed their accuracy. The defense has had the same opportunity to subpoena these records, but apparently chose not to do so." Judge Morrison reviewed the paperwork briefly. "The subpoenas appear to be in order, Mr. Morrison. You'll have time to examine these documents and respond accordingly. Mr. Holloway, please proceed with your presentation." Holloway approached the evidence table with theatrical precision. "Your Honor, these banking records reveal something quite remarkable about the funding sources for the defendant's asset protection mechanisms. According to the documentation provided by First National Trust Company, Cayman International Banking, and Wellington Holdings Corporation, the initial capitalization for all trust accounts, holding companies, and offshore arrangements was provided by a single source." Marcus felt his stomach tighten with an inexplicable sense of unease. The prenup was ironclad. His father's lawyers had assured him of that repeatedly, but something in the young attorney's tone suggested they were about to learn information that would challenge their fundamental assumptions about the case. "The total amount required for proper capitalization was substantial," Holloway continued. "Nearly $47 million spread across various accounts and financial instruments, all deposited during the 6-month period prior to the marriage. This funding was essential to creating the legal framework that the defendant now claims protects his family assets from marital division." Celeste grabbed Harrison's arm. $47 million. She hissed quietly. "Where did that money come from? I thought the trust arrangements were just legal paperwork, not actual cash deposits." Holloway paused dramatically, allowing the implications to settle across the courtroom. "The question before this court, Your Honor, is simple. Who provided the $47 million in capitalization funding that makes the defendant's prenuptial protections legally valid?" For the first time since the proceedings began, Evelyn Shin spoke in a voice that carried clearly across the silent courtroom. "Actually, Mr. Holloway, I believe there's a small error in your timeline. The initial funding wasn't deposited 6 months before the marriage. It was deposited 8 months before I even met Marcus Whitmore." The words hung in the air like a challenge, and suddenly every person in the courtroom understood that this case was about to become something entirely different from what they had expected. The Whitmore family's confident expressions began to crack as the implications of that timeline started to sink in. Stanford Morrison found himself staring at his papers, searching for information that suddenly seemed inadequate, while Marcus Whitmore felt the first cold touch of genuine fear about what his wife might know about money, trusts, and the source of his family's carefully protected wealth. The witness who entered the courtroom at 3:15 that afternoon was not what anyone had expected. Dr. Margaret Thornfield was a woman in her mid-60s with silver hair pulled back in a professional bun and the kind of quiet authority that comes from 40 years of managing other people's money. She carried herself with the precise dignity of someone who had never made a financial mistake that she couldn't correct, and her navy blue suit was expensive without being flashy. As the senior partner at Thornfield Financial Advisory Services, she had built her reputation on discretion, accuracy, and an almost supernatural ability to structure complex financial arrangements that could withstand any legal challenge. Her client list read like a who's who of old money families, technology billionaires, and entertainment industry royalty. She was not the kind of person who appeared in divorce court unless something truly extraordinary was at stake. Dr. Thornfield took the witness stand with the calm efficiency of someone who had testified in high-stakes financial cases dozens of times before. Her briefcase was a work of art in Italian leather, and when she opened it, the documents inside were organized with military precision. Each folder was labeled with color-coded tabs, and every page appeared to be arranged in exact chronological order. Judge Morrison administered the oath, and Dr. Thornfield's voice was clear and professional as she swore to tell the truth. When Holloway approached to begin his examination, the courtroom had fallen into the kind of absolute silence that precedes either triumph or catastrophe. Dr. Thornfield, Holloway began. Could you please state your professional qualifications for the court? I hold a doctorate in financial economics from the Wharton School, she replied crisply. I am a certified public accountant, a chartered financial analyst, and I have been managing complex financial portfolios for private clients for 38 years. My firm has administered over $40 billion in assets during that time period. The Whitmore family shifted uncomfortably in their seats. This was not the kind of witness they had expected to see supporting Evelyn's case. Patricia whispered urgently to her son, Marcus, who is this woman? How did she become involved in our family's financial affairs? Marcus could only shake his head. His confidence from that morning now completely evaporated. He had no idea who Dr. Thornfield was or how she had become connected to his wife's legal case. More disturbing was the growing realization that there were apparently aspects of his own family's financial structure that he didn't fully understand. Holloway continued his examination with methodical precision. Dr. Thornfield, are you familiar with the financial instruments and trust structures referenced in the prenuptial agreement between Marcus Whitmore and Evelyn Chun? Yes, she replied without hesitation. I was directly involved in designing, implementing, and managing those structures for the past 23 years. Stanford Morrison felt his stomach lurch. He had reviewed all of his clients' financial advisors and trust managers as part of his case preparation. Dr. Thornfield's name had never appeared on any of the documentation he had received from the Whitmore family attorneys. How was it possible that she had been managing their trust structures without his knowledge? Could you explain to the court the complexity and scope of these financial arrangements? Holloway asked. Dr. Thornfield opened her first folder and withdrew a document that looked like a financial flowchart. Certainly. The structures include 14 separate offshore trust entities, 6 domestic holding companies, 2 international investment partnerships, and a network of subsidiary corporations spread across 9 different jurisdictions. The total capitalization required to make these entities legally valid and operationally functional was $47.3 million. Vivian grabbed Celeste's arm. Did you know about any of this? She whispered frantically. I thought the prenup was just a simple legal document that protected our family money. I had no idea it required this kind of funding. Celeste could only stare at the witness stand in growing horror. Harrison had mentioned trust arrangements over the years, but he had always described them as routine legal protections, not complex international financial structures requiring tens of millions of dollars in backing. Dr. Thornfield continued her testimony with the dispassionate accuracy of a surgeon describing a medical procedure. The initial funding was provided through a series of wire transfers from a private investment account managed by my firm. These transfers took place over a 6-month period, beginning 14 months before Mr. Whitmore and Mrs. Chun were married. Morrison stood shakily. Objection, Your Honor. This witness has not established the source of the funding she's describing. The arrangements she's outlining could have been established by my client's family financial managers without their direct knowledge of the specific implementation details. Dr. Thornfield looked at Morrison with the kind of patient expression usually reserved for particularly slow students. Actually, Mr. Morrison, the funding source is quite clearly documented in the account management agreements and investment authorization forms that I have here in my possession. Would you like me to review those documents for the court? Judge Morrison leaned forward with obvious interest. Please proceed, Dr. Thornfield. The witness opened her second folder and withdrew a stack of documents that were clearly original banking forms complete with signatures, notary seals, and official stamps. The funding for all trust structures, holding companies, and offshore arrangements was provided by a single account holder through my firm's private wealth management division. Marcus felt his world beginning to tilt on its axis. The prenup was supposed to protect his family's wealth from his wife's potential claims. But if the financial structures that made the prenup legally valid had been funded by someone else entirely, then everything he thought he knew about his financial security was built on false assumptions. Dr. Thornfield continued her methodical revelation. The account holder in question had been a client of our firm for several years prior to the establishment of the Whitmore family trust structures. This individual possessed significant personal wealth derived from technology investments, real estate development, and various business ventures. Holloway nodded encouragingly. Dr. Thornfield, could you describe the professional background and qualifications of the account holder who provided the $47 million in trust funding? Certainly. The account holder held advanced degrees in computer science and business administration from Stanford University, had founded 3 successful technology companies by the age of 28, and had been managing a personal investment portfolio worth over $200 million at the time the trust funding was provided. Patricia Whitmore felt her carefully constructed world beginning to crumble. Everything she thought she knew about her daughter-in-law was apparently wrong. The quiet woman she had dismissed as a fortune hunter had apparently been managing a massive personal fortune during the entire 23 years of her marriage to Marcus. Harrison Jr. leaned forward desperately. "This has to be a mistake," he whispered to his wife. "There's no way Evelyn could have been some kind of technology entrepreneur. She barely even used computers during the early years of her marriage to Marcus." But Dr. Thornfield was far from finished with her testimony. "The really interesting aspect of this arrangement," she continued, "was the account holder's specific instructions regarding the management and control of the trust structures. Despite providing all the funding, the account holder requested that legal control and apparent ownership remain with the Whitmore family, while maintaining actual financial control through carefully structured voting rights and management agreements." Evelyn Shin sat quietly at the plaintiff's table, watching her husband's family absorb the implications of Dr. Thornfield's testimony. For 23 years, they had treated her like an outsider who had married into their wealth. They were about to discover that their wealth had been her creation all along, carefully hidden and protected through financial structures so sophisticated that even their own lawyers hadn't understood the true arrangements. The prenup they thought protected their assets had actually been her way of protecting her own investments in their family's future, and that investment was about to be called in with interest that had been compounding for over 2 decades. Dr. Thornfield opened her third folder with the deliberate precision of a surgeon making the most critical incision of an operation. The documents she withdrew were bound in leather portfolios, each one bearing the official seals of major international banking institutions. When she spoke, her voice carried the weight of absolute certainty. The account holder who provided the $47.3 million in trust funding was Mrs. Evelyn Chun, she announced to the stunned courtroom. All transfers were made from her personal investment portfolio managed through our private wealth division, beginning 14 months before her marriage to Mr. Whitmore and continuing through the present day. The words hit the Whitmore family like a financial tsunami. Marcus felt his face drain of color as the implications crashed over him in waves. His wife, the woman he had dismissed as a gold digger for 23 years, had been the source of the very financial protections he thought shielded his family wealth from her potential claims. Patricia Whitmore gripped her crocodile leather purse so tightly her knuckles turned white. "That's impossible," she whispered, though her voice carried across the silent courtroom. Evelyn came from nothing. She was working as a secretary when Marcus met her. She couldn't possibly have had that kind of money. Dr. Thornfield consulted her documents with professional detachment. According to our client files, Mrs. Chun founded her first technology company, Quantum Solutions, at the age of 24 while completing her graduate studies at Stanford. The company developed encryption software for financial institutions and was sold to Microsoft 3 years later for $87 million. Vivian made a small choking sound. Quantum Solutions was sold to Microsoft. But that was a huge story in the tech world. We read about it in Forbes. The founder was some mysterious young woman who refused all interviews after the sale. Her second company, Dr. Thornfield continued implacably, developed artificial intelligence algorithms for investment management. Shin Technologies was acquired by Goldman Sachs for $123 million when Mrs. Chun was 27 years old. Harrison Jr. was staring at his sister-in-law with the expression of a man watching his entire worldview collapse in real time. She founded Chin Technologies, the Chin Technologies that revolutionized algorithmic trading. But that founder was a legend in Silicon Valley. They called her the ghost of Wall Street because she never gave interviews or appeared at industry events. Stanford Morrison was frantically scribbling notes, trying to understand how his supposedly simple divorce case had transformed into a revelation about one of the most successful technology entrepreneurs of the past 3 decades. His clients had never mentioned that their daughter-in-law was a tech billionaire. How had such crucial information been completely absent from their financial disclosure statements? Dr. Thornfield was far from finished with her devastating testimony. By the time Mrs. Chun met Mr. Whitmore, her personal net worth exceeded $200 million. However, she made a deliberate decision to conceal her wealth and live modestly to ensure that any potential relationship would be based on genuine affection rather than financial considerations. Marcus felt physically sick. Every conversation he had ever had with his family about Evelyn's motivations, every cruel comment about her obvious gold-digging tendencies, every assumption about her financial desperation was being systematically destroyed by the most qualified financial expert he had ever seen. The witness opened another portfolio and withdrew a series of bank statements that looked like they belonged in a financial museum. Mrs. Chin specifically requested that our firm manage her wealth in a way that would be completely invisible to anyone who might investigate her background casually. Her personal accounts were structured through multiple layers of holding companies and investment partnerships to ensure privacy. Holloway approached the witness stand with obvious satisfaction. Dr. Thornfield, could you explain to the court why Mrs. Chun chose to fund the prenuptial agreement structures herself rather than allowing the Whitmore family to handle their own asset protection arrangements? Dr. Thornfield smiled with the first hint of personal warmth she had shown during her testimony. Mrs. Chun explained to me that she wanted to ensure the financial security of the man she loved and his family, regardless of what might happen in their relationship. She viewed the trust funding as an investment in their shared future, but she also wanted legal protections in place in case the relationship ended badly. Celeste was crying quietly, though whether from shame, shock, or pure humiliation was unclear. 23 years of treating Evelyn like a charity case. 23 years of assuming she was desperate for their money, and it turned out she had been protecting their financial security the entire time. The irony, Dr. Thornfield continued with clinical precision, is that the prenuptial agreement Mr. Whitmore believes protects his family assets actually documents Mrs. Chin's investment in supporting his family's lifestyle and business ventures. Every major expansion of the Whitmore Group, every real estate acquisition, every business opportunity was made possible by the financial backing Mrs. Chun provided through the trust structures she funded. Morrison stood on shaking legs. Your Honor, this testimony is highly prejudicial and clearly designed to inflame rather than inform. I object to this entire line of questioning. Judge Morrison looked at the defense attorney with obvious displeasure. Mr. Morrison, your clients have spent considerable time today claiming that Mrs. Chun married for money and contributed nothing to the marriage. This testimony directly addresses those claims. Your objection is overruled. Dr. Thornfield consulted her final set of documents. Mrs. Chin's current net worth, including appreciation on her original investments, compound growth over 23 years, and new business ventures established during her marriage, now exceeds $800 million. The number hung in the air like a physical presence. $800 million. Marcus had spent over 2 decades mocking his wife's humble background while she quietly built and managed a fortune that dwarfed his family's inherited wealth by a factor of 10. Patricia was sobbing openly now, her carefully maintained composure completely shattered. We treated her like she was beneath us, she whispered through her tears. All those years of making her feel unwelcome at family gatherings, all those comments about her not fitting in with our social circle, and she was supporting our entire way of life. Harrison Jr. turned to stare at his brother with genuine horror. Marcus, do you understand what this means? The business expansion that saved the family company 5 years ago, the real estate investments that have been generating our income, the trust funds that pay for our children's educations, all of it has been her money from the beginning. Evelyn Chun rose slowly from her seat at the plaintiff's table. When she spoke, her voice was calm and clear, but there was an authority in it that had never been there before during all the years the Whitmore family had known her. "Mr. Holloway," she said quietly, "I believe Dr. Thornfield has presented sufficient evidence regarding the funding sources for the prenuptial agreement. Perhaps we should move on to discussing the implications for asset division, given that the defendant's claims of ownership appear to be somewhat overstated." The transformation was complete. The quiet, submissive woman who had endured 23 years of condescension and casual cruelty had revealed herself to be one of the most successful entrepreneurs of her generation, and the family who thought they were protecting their wealth from her was about to discover that their wealth had been her generous gift all along. Stanford Morrison sat down heavily, staring at his papers as he tried to calculate just how completely his case had collapsed. The prenup he thought would protect his client's assets had actually documented their financial dependence on the woman they were trying to divorce, and that woman was about to reclaim every dollar she had invested in their ungrateful family. Judge Helena Morrison had presided over thousands of divorce cases during her 30-year career, but she had never seen a more complete reversal of circumstances than what had unfolded in her courtroom that afternoon. She reviewed the financial documentation one final time before delivering her verdict, her expression grave as she considered the implications of what had been revealed. "The evidence presented today," Judge Morrison began, her voice carrying the weight of absolute authority, "demonstrates that the defendant's claims regarding asset protection are fundamentally flawed. The prenuptial agreement in question was funded entirely by the plaintiff, making it, in essence, a document that protects Mrs. Chin's investments rather than Mr. Whitmore's inherited assets." Stanford Morrison sat in stunned silence, his legendary reputation crumbling with each word from the bench. 40 years of legal practice, and he had never encountered a case where the asset protection mechanisms had been secretly funded by the person they were supposedly designed to exclude. His clients had played him for a fool, and worse, they had apparently played themselves for fools as well. Given the clear evidence that Mrs. Chun provided the financial foundation for all trust structures, business investments, and real estate holdings claimed by the defendant, Judge Morrison continued, "This court awards Mrs. Chun full ownership of all assets funded through her investment portfolio, including the Whitmore Group companies, the family estate, and all subsidiary properties." Marcus Whitmore felt his world collapse completely. The family business that bore his name, the estate where he had grown up, the investment portfolios that had supported his lifestyle for decades, all of it was being transferred to the woman he had spent 23 years treating like an unwelcome charity case. Patricia Whitmore let out a sound that was part sob and part wail. Everything. They were losing everything. The social standing that came with the family name, the financial security that had defined their identity for generations, the respect they commanded in their exclusive social circles. It was all evaporating because they had been too arrogant to understand what they actually possessed. Furthermore, Judge Morrison continued with obvious satisfaction, given Mr. Whitmore's documented statements claiming that Mrs. Chun contributed nothing to the marriage and lived off his family's generosity. This court orders that he pay spousal support in the amount of $50,000 per month for a period of 10 years, retroactive to the date of separation. Vivian made a strangled noise. $50,000 a month. Marcus didn't have $50,000 total in his personal accounts. Everything they thought belonged to him had actually been Evelyn's money all along. Judge Morrison was not finished delivering consequences. Additionally, given the testimony regarding Mrs. Chin's funding of family members' educations, living expenses, and business ventures without their knowledge, this court orders that Harrison Whitmore Jr., Patricia Whitmore, and Vivian Whitmore Sterling each pay restitution to Mrs. Chun in the amount of $2 million to compensate for benefits received under false pretenses. Harrison Jr. felt his stomach drop through the floor. $2 million. He didn't have $2 million. His trust fund, his investments, his house, everything was tied up in financial structures that apparently belonged to his sister-in-law. He would have to liquidate his entire life to pay a debt he hadn't even known he owed. Celeste was hyperventilating quietly. Their children's private school educations, their country club memberships, their annual trips to Europe, all of it had been funded by the woman they had spent decades excluding from family photos and social events. The humiliation was beyond comprehension. As the judge concluded the formal proceedings, Evelyn Shin rose from her chair with the composed dignity of someone who had finally stepped out of a role she had been playing for far too long. When she turned to address the Whitmore family, her voice carried the quiet authority of a woman who controlled an $800 million empire. "Marcus," she said, her tone neither cruel nor kind, simply matter-of-fact, "I want you to understand something. Every insult your family directed at me over the years, every assumption about my motivations, every moment you made me feel unwelcome in my own home, I accepted because I loved you and hoped that eventually you would see me as a person rather than a threat to your social status." Marcus couldn't meet her eyes. The weight of 23 years of casual cruelty was crushing him, made infinitely worse by the knowledge that she had been supporting his family's entire way of life while enduring their contempt. "Patricia," Evelyn continued, turning to her former mother-in-law, "you often told people that I married your son for money. You were half right. I didn't marry him for money. I married him to use my money to give him and his family the financial security to live without fear, to pursue opportunities without risk, to build something lasting together. I never imagined that generosity would be mistaken for greed." Patricia was crying too hard to respond, her carefully constructed worldview in complete ruins. She had spent decades protecting her family from a gold digger who had actually been their guardian angel, and the irony was destroying her from the inside. "Harrison, Vivian," Evelyn's gaze moved to the siblings who had made sport of excluding her from family discussions about business and investments. "You both inherit management positions in companies that I built. You receive trust fund distributions from accounts that I funded. You sent your children to schools that I paid for. And through it all, you treated me like I was beneath your notice because I didn't come from the right family or attend the right social events." Harrison Jr. was staring at his hands, unable to process the magnitude of their collective misjudgment. They had treated the most successful member of their family like a servant, and she had quietly continued supporting them anyway. Evelyn turned back to Marcus one final time. "The saddest part is that I would have been happy to share everything I had built if you had ever once treated me like an equal partner instead of a burden you were obligated to tolerate. But you chose to see me as someone trying to take from you rather than someone trying to build with you." The courtroom emptied slowly as news crews began gathering outside. Word of the case was already spreading through social media and financial news networks. The headline practically wrote itself. "Tech billionaire reveals 23-year marriage to family who called her gold digger." By evening, the story had exploded across every major news platform. Financial reporters were dissecting Evelyn Chin's legendary business career, previously hidden behind layers of privacy and corporate structures. Technology journalists were connecting her to major innovations that had shaped the digital economy for decades. Society columnists were analyzing the social implications of a family so completely misunderstanding their own financial circumstances. The Whitmore name, once synonymous with old money respectability, became a cautionary tale about arrogance and ingratitude. Their exclusive country club quietly suggested they consider resigning their membership. Their social circle began treating them with the kind of polite distance usually reserved for financial pariahs. The business community started questioning how they could have been so completely unaware of their own company's funding sources. Marcus moved into a modest apartment, his spousal support payments consuming most of his limited income from a middle management position Evelyn had arranged for him at one of her subsidiary companies. She had ensured he wouldn't be destitute, but he would live the kind of ordinary life he had once considered beneath his dignity. Patricia sold her jewelry collection to help pay her restitution debt and moved into a senior living community that accepted residents with limited financial resources. The woman who had once hosted charity galas for causes she had never personally supported now spent her time volunteering at food banks, finally understanding what it meant to worry about money. Harrison Jr. and Vivian both declared bankruptcy within 6 months, their lifestyle finally matching their actual earning capacity rather than their imagined inheritance. They found jobs in middle management at companies where their names meant nothing, learning for the first time in their lives what it felt like to work for a living rather than living off investments they had never earned. Evelyn Shun moved into a penthouse overlooking the city, her technology companies continuing to innovate and expand under her direct leadership for the first time in decades. She established a foundation supporting women entrepreneurs, particularly those who had been underestimated or dismissed by traditional business networks. The foundation's motto was simple: see the person, not the assumptions. She never remarried, though not for lack of opportunities. Instead, she focused on building something that would last beyond any single relationship, a business empire that created opportunities for others who had been overlooked, undervalued, or dismissed by people who mistook quiet confidence for weakness. The lesson of Evelyn Chen's story spread far beyond one family's spectacular misjudgment. It became a reminder that the most dangerous assumptions are often the ones that prevent us from seeing what's directly in front of us, and that true power often lies in the hands of those who choose not to display it until the moment when revelation serves a greater purpose than concealment. Sometimes the person you think needs your charity is actually the person providing it, and sometimes the greatest act of generosity is allowing people to reveal their true character before you respond in kind. Evelyn Chen had given the Whitmore family 23 years to see her as she truly was, and when they consistently chose blindness over sight, she finally opened their eyes in the most definitive way possible. Have you ever encountered someone who completely surprised you when you learned their true story? Someone whose quiet strength masked capabilities you never imagined? Share your thoughts in the comments below, because stories like Evelyn's remind us that the most interesting people are often the ones who choose to let their actions speak louder than their status symbols. And the most dangerous mistake we can make is assuming we understand someone's worth based on our own limited perspective.